Welcome class to the week 2 lecture. Let's go ahead and get started. So what you need to know, or as far as your objectives, is you need to know the differences between criminal law and civil law and how they work, the historical influences that influenced United States American law. You need to be able to tell apart the 4 different sources of law. You need to be able to discuss the burden of proof required for both a criminal and civil case, define the 4 components of a criminal act, and explain the different types of criminal defense. So let's go ahead and get started with civil cases. So civil law, right? This is the type of law that will be able to handle disputes between private parties or individuals. So this could be corporations or 2 people, right? And the type of instances that we see here are tort, okay, contracts, property, or family disputes. So for example, there's a breach of contract between an athlete and the sporting team that he used to be employed by, and let's say they release him and they are no longer requiring his or her services. That athlete may be able to potentially sue the sporting team if they're not paying out the fee to let them go of their contract. Or let's say this happens in other countries where they're not as financially stable. There might be athletes who are not being paid what the contract said they would be paid because of the lack of economic success by the team. Another good example might be family disputes, right? Which we'll see a picture of in a little bit. So when there's a divorce, for example, does someone have to pay the other individual alimony? Is there child support to be paid? Who has custody of the child? If the house is sold, who's going to keep what? If there was any equity left, etc. Right? So this could get pretty complicated, right? So anything to have to do from contracts all the way to family law. Now, the individuals involved in a civil case will be the plaintiff, which is a person suing the defendants, and the defendants obviously defending themselves from the plaintiff. So think of the plaintiff in the civil case as the offense, while the defendant is a defense. Now, the burden of proof in a civil case is preponderance of the evidence, right? And if you turn to page 25 of your textbook, you'll see a pyramid. And preponderance of the evidence is greater than probable cause and reasonable suspicion, and accusations are more likely than not to be true. Notice how it's more likely than not, and this is not as high as the tip top, which is beyond a reasonable doubt, which we'll discuss in a little while. The punishments in a civil case are not like those in a criminal case where you will not be incarcerated or whatnot. You will more than likely face financial punishment. That is usually what we'll see in a civil case. Financial punishment is what you'll see in a civil case. So it could be a restitution, pay what is owed, etc. A fine. Now in criminal cases, okay, it's a little bit different. And here we have the picture that I was discussing earlier, right? It looks like the family, maybe husband and wife are getting separated, they're getting divorced, and they're trying to figure out who gets custody of the child, what days, what percentage of the time, etc. And these individuals are not facing incarceration or anything of that nature as far as punishment, quote unquote, goes, compared to criminal law, where the individual in the orange jumpsuit is handcuffed, and if they are found guilty or plead guilty, more than likely will end up serving some jail or prison time. Now, in a civil case, I indicated that one person will bring the case against the other, whereas in a criminal case, it is the government that brings the case against the defendant. So the government is the plaintiff, okay? So let's say that one individual is being tried for battery. Yes, they may have assaulted somebody, okay? But it is the government that is bringing the case against the defendant. The government might use the victim as evidence, but it is the government that will bring the case against that individual, and that is why if you see in a docket for a criminal case, it will say, if it's a state, under state jurisdiction, it will say Florida versus Smith, for example, or if it's federal, United States versus Smith, because when you commit that crime, you might not only commit it against another person, but you're also committing it against society. Now, the burden of proof in a criminal case is beyond a reasonable doubt, which, as you will see here, it is the highest burden of proof, and it requires elimination of every other reasonable doubt that this individual was the individual that committed the crime. All right. Again, this same pyramid is on page 25 of your text. Now, we have different types of punishments for criminal cases, right? And obviously they depend on the crime. You're not going to give somebody who purse snatched the same thing as someone who committed a homicide, right? So we have probation, we have incarceration, and we have, what seems like the ultimate punishment, which is execution. So there's federal and state and municipal laws, and I'm going to start with federal, right? And the federal laws are those crimes essentially against the United States of America, against the country as a whole, right? And the individuals that make this are the United States Congress, right? Our legislative branch. They're the ones that make the laws, and this, governs activities also on the federal government buildings, national parks and tribal lands. So if you also do anything in those areas, you may be tried for violating a federal crime. And then in instances, right, where let's say you do some type of crime and it starts in Florida and then it ends in Georgia, it could also become a federal crime because that is across state lines. The picture I have here is a plane with what seems like some type of illegal drug or illicit substance being, brought in from one country to another. The reason I use this picture is because if you bring in drugs from one country into the United States, you're committing a crime against the United States. So that would be a federal crime. And the next slide has other examples, right? So some could be firearm laws, like I said earlier, bringing in drugs, money laundering because you're using banks, or fraud, okay? Even bank robbery, if I'm not mistaken, could be a federal crime because the money in a bank is insured by the federal government. So if you have any questions about federal law, we could discuss this in class, or make sure to write it down. Then we have state criminal laws, okay? Now, if you're familiar with our Constitution, or you had me for your civics class, the 10th Amendment is the states' rights. So states can make their own laws, and they could be very different from each other, right? So these laws are specific to the geographic jurisdiction of that state, right? So what Florida says goes in Florida may not be the same in Georgia or California or New York, right? And criminal behavior definition, may vary from state to state, and I'll discuss that in a minute. And so will the punishments. So criminal behavior, right, may vary from state to state. So in Florida, if you want to smoke marijuana recreationally, that is considered a crime. Whereas in other states like Colorado, California, as you see here in the picture, the states on the West Coast, it might not be crime if you purchase it legally and if you're doing it in your home, right? And here we see in Texas, for example, you cannot consume marijuana for recreational or medical use. And this is not only regarding marijuana. This is regarding many other things. For example, abortions. Some states are more lenient on abortions, while others are more strict. Gun laws. Some states it's easier to acquire or purchase a gun, where in other states they have really strict rules about who can and cannot obtain a weapon, and how quickly you can do it. So all states can make their own laws regarding the issues that they feel are relevant or important enough to tackle. Also, punishments vary, by states. One state, one crime might have X amount of months in prison, right? Like let's say 24 months for X crime. That's 2 years. Where in other states, that might give you a year and a half. Some states allow the death penalty, while others do not. Then we have municipal crimes, right? These are the most limited laws, and these are the crimes in specific municipalities, cities, or towns, right? So for example, Miami-Dade County is a county, but it has different municipalities within it. If I'm not mistaken, it has 32 different municipalities or townships. So think about, for example, the city of Hialeah, that is a city. The city of Sweetwater, that is a city. Where our school is unincorporated Dade. So that's not in a city, but it is within the county. Miami Beach is another city. So they might have their own municipal laws or ordinances, right? And these things are usually cases that involve, infractions or misdemeanors, because the state will usually determine, and the federal government, what is a felony, right? Like Sweetwater is not going to say a high felony like battery or drug trafficking is not that big a deal, whereas Coral Gables might. No, those are that's a federal crime, so they're going to handle the more minor stuff, like infractions, right? And these are violations that it's punishable by a fine, but doesn't really carry a potential jail sentence. Think of traffic violations, jaywalking, and disturbing the peace, right? So you might see different jaywalking laws, right, which will not carry a jail sentence in Coral Gables or Sweetwater or the beach, right, where there's a lot more pedestrian traffic, right? They want it in the beach to have a lot. The individuals on the beach want there to be a lot more order when it comes to pedestrian traffic because of the high volume of individuals walking. Now we're going to transition a little bit and discuss the sources of law that are available. And by sources of law, this is, throughout history, we've made references to other legal systems and where we get our ideas to have our current laws. So the first one is the Code of Hammurabi. And as you can see, it's pretty old, okay? It has 282 codified laws, and it's known for lex talionis. I'm not exactly sure how to pronounce it, so I won't. It's the punishment should fit the nature of the crime. And if you've ever heard the term eye for an eye, this is where it comes from. So the example they give in the text is, the law against slander stated that if anyone point the finger at a sister of a god or the wife of anyone and cannot prove it, this man shall be taken before the judges and his brow shall be marked. Okay, so the punishment must fit the crime. Again, you're not going to give a purse snatcher the same amount of time as somebody who committed a homicide. Okay, and then we have Roman law, right? Roman law developed through centuries of customs that were passed down from one generation to another, and the laws were put, I would say on paper, probably not back then, were codified into what we have as the 12 tables and stood as, the foundation of Roman law. Now, remember, the Roman Empire was really big and it expanded all over Europe. So Roman law influenced a lot of European countries. And why has it influenced the United States somewhat? Well, because remember, we are a colony of an area that also used to be under the Roman Empire, right? So Roman law is what's considered to be the first legal scholars, and it has influenced a lot of countries in the Western Hemisphere. So think of Western Europe, or really, Europe in general, and the Western Hemisphere, the Americas. We also have English common law, right? In English common law, we could see coming from the Middle Ages, okay, and we have something here that has taken a really big influence on the United States, and that is a president. So when you take into account the previous rulings, so if any of you remember in your civics classes, or you've ever heard of something like Miranda rights, right? When someone gets arrested, that is from Miranda, the Miranda versus Arizona Supreme Court case. So what that did there was set the precedent, meaning that after that decision was taken, future legal decisions are required to take into account that specific ruling. So after someone's put in handcuffs, it is the standard if they're going to be interrogated or even just arrested that they read their Miranda rights. So that one set the precedent to do that. So we probably won't see another case similar to that in the Supreme Court, because that one set what's called the precedent. So something that English common law gave us was that, and stare decisis, to stand by things that are settled. Okay. Again, if you need clarification on any of these, you could just ask me in class. And then we have constitutional law. Okay, so we have 1787, Philadelphia and the Constitutional Convention, right? This is when our founding fathers wrote the Constitution, and the Constitution is pretty much a rule book for the way that the United States operates. It is considered the highest law of the land, and it incorporates the Bill of Rights, which were initially not to be included, right? But if you remember the lesson from the Federalist and Anti-Federalist, one group advocated for them, right? And they advocated saying that we need those specific rights outlined in the Constitution because those rights will protect us from a tyrannical government, right? And when it says here binding, it means that the U.S. Constitution is applicable to all the United States, right? To all U.S. states, to D.C., and to our territory. So, for example, to Puerto Rico, right? And then we also have the states' constitutions. So here are some of the rights that are protected by the U.S. Constitution. Again, if you remember from civics, right, like the First Amendment, it will protect your religion, your freedom to practice or not practice religion, freedom of speech, the press, right? The press could write stories against the government, and the government can't do anything about it. Second Amendment, the right to bear arms, that we can own guns. So all these, right, are rights that we have to protect us from the government. But more importantly, I want to go to the due process rights, right? So look at 5, look at 6, look at 8. These are amendments that protect us when we are being tried of a crime within the United States, okay? So we have the right to a speedy trial and an impartial jury, right, in front of our peers, according to the 6th Amendment. The right to be informed of the nature of our charges. We could confront our witnesses against us, present witnesses in our defense, and we could have the right to an attorney. All this is because these are rights that were not given to the colonists when we were colonies of Britain. So our founding fathers made sure that we had these rights protected when we were, in a trial. The 4th Amendment, right? The government can't just come and barge in our house unless they have some type of probable cause. Okay. The 8th Amendment, excessive bail and cruel and unusual punishment, right? And then lastly, due process protections to the states to make sure that everybody gets equal protection of all these amendments or rights to protect us from the government. Then we have statutory law, right? And these are laws that are established by state governments, and this is why you see the picture here of Florida statutes, right? Statutory laws could be created by the federal government or the state government, right? So it is the U.S. Congress who will make them for the federal government, where the Florida Congress legislature will make them for the state of Florida, and that's the Florida statutes. So these are laws, in the state of Florida. Then we have administrative law, and administrative law derives practically from the Federal Administrative Protection Act, which regulates how government agencies are created and how they function, right? And it lists the powers that are that are granted to these agencies. And one example I'd like to give for administrative law is, if you're familiar with the 4th Amendment, and if you're not, it's okay because we'll discuss it, down the road, is that a police officer needs reasonable suspicion to pull you over, right? Let's say a broken taillight, or you take the stop sign, and probable cause to search your vehicle, correct? Well, it's a little bit different for customs, because customs generally operates along our borders, right? So there, Customs and Border Patrol, they could go around the 4th Amendment when they're near a port of entry, and they could search your vehicle without having probable cause, without having reasonable suspicion to even pull you over just because you're at the border. So think about when you're at the airport and they might search your bags. Is it because they suspect that you committed a crime, or just anybody could commit a crime, could bring in anything illegally in here? And when they do it, it's not considered a violation of rights because of the Administrative Procedure Act, that they have this leeway to go ahead and go around the 4th Amendment. Then we have international law. So if you've ever heard of the United Nations, it's all the countries coming together, and they're trying to oversee and promote human rights, prevent or try international crimes. They're trying to help refugees and migration issues, trying to make sure that the conditions of war don't get worse, and just any global issues. For example, climate change, right? So here we have the United Nations Charter, which was in 1945. So think of the U.S. Constitution, but for the United Nations, for the entire world, that was created right after World War II. And this is something that, all countries, it's not legally binding, right? Not all countries have to follow, but, the United Nations will argue that they should. We also have the International Court of Justice, and this is where they will bring, for example, war criminals and try them for their war crimes. And this is the judicial branch, meaning the court branch of the United Nations. So if they have enough evidence to try someone, so I believe in the Rwandan genocide, or maybe in Yugoslavia, they were able to try some of the leaders there, and it was done here in the International Court of Justice. Feel free to search anybody who's been tried here, or we could discuss it in class. But yes, this is where they'll try these individuals, and this is like a world court to handle world issues. So here we have a picture of the UN Security Council. All right, these are my understanding, the 14 countries within the Security Council. We won't get too much into the UN. If you have any questions, ask me in class of how the UN Security Council works and the 5 permanent members and whatnot, but I'm going to skip that for now. Then we have case law, right? So case law is excuse me, give me 1 second. I have to pause here. All right, I apologize, folks. Let's go ahead and continue. Where was I? All right, so case law. So remember what I was saying earlier about English common law that sets a precedent. So in this case, a case law is created, as a result of legal decisions, and it will set a precedent. It usually involves, a judge or a panel of judges who provide a written explanation of the actual decision in the court case. So think of your appellate courts when you appeal something in a decision they give, or in the U.S. Supreme Court, right? And this is where you have that panel of judges and they'll decide something. So what these laws will do, right, the case law, it might challenge statutory law, whether it's federal or whether it's state law, right? They might challenge a statute. So they might say that, hey, that statute is not constitutional. It's violating my rights. So that's why they might appeal the case. And when you were in civics, there was a bunch of landmark cases, right? Like Tinker versus Des Moines, that was about the First Amendment related to that. Or Miranda versus Arizona, due process. Okay, Gideon versus Wainwright, right? He came out and said, hey, the state of Florida is violating my due process because I'm not getting an attorney. And at the time, the only people that were required to get an attorney, paid for by the government, were people that were accused of a federal crime. But then, right, this challenged Florida statutory law, saying that in Florida, it was only people being tried for a capital crime, which is something that they might get the death penalty for. So this challenged Florida's statutory law and changed it that all the states in the United States had to now provide free counsel or an attorney to someone who couldn't afford one. Okay, so it set that precedent that now everybody who's indigent, who does not have the money to pay for an attorney, can do so. So if I confuse you a little bit, I'll clarify in class. So these were the different types of laws, right? Municipal, state, federal, and international law. Now we're going to go into different types of crime. So first of all, we have mala in se, okay, which are acts that are considered to be inherently illegal, right? Morally speaking, ethically speaking, You don't have to tell me that murder is wrong. You're taking somebody else's life, right? But then we have mala prohibita, right? That is society saying that, hey, these things should be illegal, right? They're crimes because society and our elected officials have determined that this thing is illegal, right? So for example, drug use, prostitution, gambling. These things, some individuals might not see them as wrong or criminal, right? Versus something mala ensia like murder or assault. But society will determine that drug use, right, might be morally wrong. Or they might say, hey, drug use is okay as long as you're a certain age, right? Like in Colorado, they might allow individuals of a certain age use marijuana recreationally, right? Or gambling. Gambling might be allowed in some jurisdictions, one other it's not, whereas murder is not allowed in any jurisdictions. So then we have the components of a criminal act, right? So first it takes us to actus reus, right? And look at the root of the word actus. It's the act, right? It's the evil act. The word actus and reus are, in Latin. So we need the the evil act, right, to be there. Then we have the mens rea, right? So think of mens like mental, right? The mentality is the evil thought that accompanies the crime, right? So you need those two elements. And then you need the attendant circumstances, right? The context of the act that makes it a crime. So in a criminal case, right, look here. The actual prosecutor must prove that, yes, there was physical action, right? Let's say somebody gets punched, but the state of mind was that was the intention of the individual to punch the other person, right? And then the result of actus rea, mens rea, and the attendant circumstances is that a crime will be committed, as you see here, right? So you have the action, the attendant circumstances, right, leads to the actus reus, the mens rea, which is a concurrence together, right? When they're together, it's considered concurrence, which results in a criminal act. And this is seen on page 32. Okay? Give me 1 second.